Welcome to today's case sponsored by the letter S, as in summary suspension. The facts of this case involved a nurse who was the subject of allegations of workplace misconduct, which ultimately culminated in this nurse's arrest for assault. The nursing board engaged in an investigation and ultimately issued an order of a summary suspension. This occurred on November 12 of 2020. Thereafter, the board noticed up a hearing on November 18th, and the hearing date was scheduled for December 1st. So it was a relatively short time period from the hearing notice to the actual hearing date itself. The hearing was held before an administrative law judge, and the licensee, the nurse, appeared pro se, arguing that he did not have enough time to find a lawyer. Ultimately, 6 weeks later, the administrative law judge entered a recommended order of revocation, permanent revocation of licensure, which the board adopted. The licensee appealed, and the Superior Court upheld the summary suspension but reversed the revocation order. And the argument was over the notice period and due process ultimately. The board appealed the reversal of the revocation, and the appellate court ultimately affirmed this reversal, finding that the lack of notice, if you will, the 13-day notice period, was not consistent with the law in Arizona, which requires at a minimum a 30-day notice period to allow a respondent to prepare a defense. The board argued that the 13-day notice period was an attempt to deal with or address the summary suspension and have a timely hearing also required under statute. And the court ultimately said that summary suspension route is meant to facilitate the dictates of due process, not inhibit them, and the board cannot exploit that rule to justify a lesser process, if you will, a lesser notice period. The board finally argued that the nurse waived the due process or 30-day requirement period by appearing at that December 1st hearing, and the court was having none of that, and relatively easily affirmed the lower court's reversal of the permanent revocation. So this is an important case that pits the notice period found in an Administrative Procedures Act against an ambiguous, timely notice when you're dealing with a summary suspension. So stay tuned for future regulatory issues that we can address related to the legal side of professional regulation.